All right, hello everyone. We are going to go ahead and get started. Today we have a webinar on how to cover your ass. How can you protect yourself on the front end before disputes even arise? Here at the Cromines Law Firm, we're all about preventative measures to keep you out of the courtroom. So today our lead senior attorney, Courtney Strickland, she's going to go over kind of 4 key things that we really preach to our customers on, making sure they're doing consistently and before dispute arises. And that's going to be the submittal process, field conditions, prior work, and lien waivers. And if I can ask if everyone can please stay muted during the presentation, we are going to end it with a Q&A. And if you have questions throughout the presentation, feel free to put them in through the chat and I'll read the questions out at the end of the presentation, or you can unmute yourself at the end to ask the questions. So, Courtney, why don't you go ahead and get started?
Okay. Hi, thank you guys so much for joining. I'm glad you guys could be with us. And so we're going to talk about some issues that, as a construction attorney, unfortunately, we've had to be on the wrong side of. So the first thing that we're going to talk about is the submittal process. And if you're somebody who kind of does, if you're a material, if you deal with material or steel or stone or brick or something like that, one of the things that you should know about is the submittal process. And so that process is basically making sure the GC knows all of the technical information about your work. So if you're going to be putting up a stone wall, or if you're going to be doing framing or drywall or paint or whatever, you're going to make sure that you send either a sample, any information about the product, the specifications, shop drawings, all of that gets submitted to the GC first. So what you want to make sure, I'm sorry, let me move this along. But you want to make sure, if you have access to this, you want to make sure that you can do a mock-up. And so a mock-up is basically where you have a small part of the project and you do a small portion of it there. That way the owner or the GC is going to be able to see exactly what your scope of work is going to look like before the job really gets started. And so typically this is required for the exterior of a project. All right, and so it's important because if you've gone through this submittal process where you've allowed the general contractor, the owner, the architect, if everybody has seen all of your information, your products, the warranties that are attached to it, the shop drawings, specifications, if you've given that over and they've seen it and they approve it, then you're in pretty good shape as far as there being any kind of question about the quality of your work coming up later on. So by accepting that, they're saying, you know what, these are the right materials. This is the right paint color. This is the right color brick or the right texture or whatever. Their acceptance of that really puts you in a good position, because as long as you're still using that, they can't come back in later and say, oh no, we never approved that. We don't want to use that anymore. So it's good for 2 things. One, obviously the integrity of the project. They want to have something that says this is what we said we were going to build, and so that's what you're providing to them through the submittal process. But it's really good for you, because then later on, if they're trying to say, no, you did not do what you were supposed to do, you can come back and say, actually, you approved what I was supposed to do a long time ago, and exactly what I gave you here is what I installed. So you can't tell me now that you don't appreciate it when before you did. So it's very good, it's very effective, and it's a good practice to have, even if it's not typically something that you would see in your subcontract. It's still something you want to try to push through anyway. All right, so in the real world, if you want to make sure that you're following this step, you want to make sure that you have that submittal approval in writing. So you submit whatever you need to submit. It could be a sample tile or a sample paint swatch or whatever it is, your shop drawings, all of that. You can go ahead and submit that, but make sure that the approval is done in writing, whether it's email or you actually have a physical piece of paper that's signed off on, or a text message, something that says, hey, look, I looked at your samples, I looked at your mock-up, and everything is good to go. You want to make sure you have a copy of that. Save it somewhere in your project file that you can easily pull it out or that you can easily refer to it. So that way, if there is a dispute, you can pretty much head them off really quickly by saying, no, this is what you gave me, this is what you approved for. Here, I have proof because the GC signed this. So you definitely want to do that up front, and you want to make sure you're documenting all of your work. If there are changes and recommendations that are made, let's say that they say, you know what, we no longer want this color, we want a different color. You want to go ahead and make sure that you have the change approved before you implement it into the project. You want that already marked down. If they're going to say something like, you know what, I know we told you to do exterior doors, and then they say, oh, wait, we want to do interior doors instead. And you say, well, wait a second. Interior doors are not going to work for an exterior door. You're going to end up having some damage, or something is going to happen here that's not going to work. And if it's not in writing that you're telling them, hey, I know you want to do this, but this isn't a good idea, and there's no record of it being approved anyway, then you could potentially be held liable for having to replace it, even though you knew better. If there's no record that they decided they wanted it against your recommendation, then you have that scope of work in your project, and effectively you have now supplied some sort of breach. There's a breach of warranty, there's a breach of contract, you have a defective product, and that's going to be your responsibility. So the next thing we're going to talk about is field conditions. You know, it's one of those steps in a contract that it's easy to just kind of look over, or it's easy to just assume, oh, it's fine. I know, you know, I recognize what kind of project this is. I'm not going to go ahead and go out to the property. But we've been on a couple of cases where it was really crucial that our subcontractor go out to the property and check out the field conditions when they have the chance. So what a field condition is the physical property of the project wherever you are going to be providing work. So it could be where the property is, where the project is, how can you access it? Is there storage available? Is the area that you're looking to work on, do you have to have, you know, certain things nearby, or is it further away? You want to be able to go out to the project and survey that, so that way you have an understanding of everything you're going to need for your scope of work. So you want to do that because there's typically a language in the contract that says that you have actually gone out to the property and you inspected it and you're totally fine with the way the property looks. And if you haven't done that, you're pretty much signing off saying that you have, and that could come back and bite you in the long run, because there could be something about the area that might cause you additional expenses in order for you to complete your scope. So if you have not adjusted your bid for these additional expenses because you have not been to the property and taken it into account, that's going to come out of your pocket. I mean, it's a pretty valid argument for them to say, hey, look, they went out there, it's in the contract, they signed the contract, so they knew exactly what was required of them, and they still gave us the same amount. So, you know, we're good to go. That's on their cost. They decided that they weren't going to do what they needed to do by going out to the property. So this has happened actually in a couple of situations that we've been involved in. We've had contractors that were supposed to deal with an electrical issue, or they were responsible for the electrical scope, but then you go out to the property and the electrical box was not where it was supposed to be, and it was limited on who could access it, and that caused a lot of problems and delays on the project, because the only person who was allowed to access it was only available certain times of the day, or certain days out of the week, and that caused a lot of delays. There was also a case where we had somebody who they were required to haul certain things off, and the place that they were required to haul it to ended up increasing their costs by a significant amount because it was so far away, but they agreed to do it without accounting for that extra cost. So it's really important that you're careful about that. I think another example of something like that was a contractor who had a barge, and they were going to have to basically repair a pier. And in order to do that, they had to basically set the barge exactly in the water where it was supposed to be, and that took a lot of time and effort. But boats would come in, and they had to unload right where they had the barge, and so that required a lot of mobilizing and demobilizing to the tune of $30,000 that they never included in their costs. Now, had they gone out to the property and had they seen, okay, look, this is where we're supposed to, also repair, but it's also where people are going to be trying to unload at the same time. So we have to be able to account for how many times in a day that we're going to have to do all this mobilization. So you want to make sure, if you're going to agree to any specific terms or provisions, you go out there. It's worth it to send somebody out there, take a look at where you are, where you're supposed to be, even if you just put your eyes on it, because really, you're going to be responsible for anything that you could have seen had you actually gone out to the project. All right, so a couple of things that you want to think about when going to the project is, where are you supposed to park? Is it free? Is there enough space? Are you going to have to pay? You have to do some alternative way of getting to the job. And these are all questions and things that you're going to have to include into your price. Is there a restroom? Are you going to have to bring your own porta potty? We already talked about the mobilizing. Storage. Are you going to have to provide your own storage? Is there a place to put it? Are they going to have a safe place there for you? And then, are you going to need safety gear? Is that going to be provided, or are you going to have to purchase it on your own? Again, all things that need to be considered whenever you get ready to start your work. So you want to include all those in your price. All right, so prior work. Oh boy, this one is kind of a heartbreaking thing, because it doesn't seem to make a lot of sense at first, but what'll happen is you might be hired on a job. So prior work is all the work of any subs that happened before you. So if you're further down in the timeline and your scope doesn't happen until A, B, C, and D are done, and then you go and you perform your scope of work and find that there's something wrong, or the owner or the GC says, hey, there's something wrong, you and everybody else who worked before you can be held liable for that defective work, even if you had nothing to do with it. Unfortunately, we've got a pretty big case like that right now, where our sub was just pulled into a lawsuit, and it really it's trying to find where the defective work is, and there's so many subs involved, and there's a pretty tight contract that says everybody could be liable. It's so costly, even just to be in it, even when you know you didn't do anything wrong. So you definitely want to be really careful about agreeing to the construction contract, and make sure you read it carefully, because you don't want to be held liable for defective work of somebody who did that job before you ever got on. So in order to prevent that from happening, when it's time for you to start your scope of work, look at the project carefully, inspect it, see if there's any defects in the work before you ever start. You want to put all of those defects in writing and send it to the general contractor. Do not start working until you have all of that stuff written down and sent over to the GC, and the GC has told you in writing how to proceed. So let's say you're painting and it comes back, oh, there's some kind of defective work here. And it turns out, oh, well, maybe the drywall was bad. And the drywall was like, well, maybe the framing was bad. And then all of a sudden, everybody who's ever been involved in painting or doing anything with this one building is now tied into a lawsuit and potentially owing somebody money, and assuredly owing their attorney money, because now they're in the lawsuit. You want to make sure that you report every defect you can find. Just do your due diligence. Get out there, take a look at it, and make sure there's nothing wrong, because you don't want to be responsible for somebody else's bad work. You also don't want to take somebody's word for it. And by somebody, I mean the GC, by saying, oh, no, it's fine. Just go ahead and paint over it, or go ahead and put the drywall on, or whatever it may be. You want to make sure that they have addressed your issues in writing. That way they can't come back later and say, well, You didn't tell us. You accepted all of their work when you started, so now it's your problem. So this is a contract provision that you'll see, and we've seen these in many contracts before, and it's terrible. Especially for subs, it is a terrible, terrible provision. And the worst part about it is if you look at the very last line there, it says, if subcontractor fails to find and report in writing any defects, subcontractor shall be liable to general contractor for all costs and damages arising out of or relating to any such failure. And that includes any errors, omissions, or inconsistencies, or any such variance. I mean, you're agreeing to take on somebody else's bad work. You're agreeing to be responsible for that. As much as you can scratch this off of a contract before you sign it, scratch it off. I mean, just say, you know, put an X through it, sign your initials saying you're not agreeing to that, because it's really a terrible provision in a contract. It really means that everybody can be sued. So I would recommend, as much as you can negotiate this out of a contract, definitely do that. Also, if you're going to have it left in, then do the inspection first. Cover yourself. Do the inspection, put everything in writing, and then put it on the GC. Now it's their problem because you told them, and this is how they told you to proceed. And I think now we are moving on to the very last part of this, which is lien waivers. Most contractors are really aware of the lien process. I know we've done a lot of webinars on filing a lien. This is focusing on the waiver. Lien waivers can get you in trouble if you don't know what you're signing. And there's a lot of dirty business out there when it comes to subcontractors and GCs. And so basically a lien waiver means you're waiving your right to your lien. It's a receipt, it's a document. It says, hey, I got money for this work, so now I no longer have the right to file a lien. So when you do that, you give up that opportunity to file. That's your leverage, right? Let's say you haven't gotten paid all the way, but you sign off on this lien waiver. Now you don't have any leverage because all it's going to take is for them to show you this document that says, hey, you signed this. Your attorney is going to kind of shrug and say, I'm sorry, I can't help you now because you waived your right to a lien. So you definitely want to make sure before you sign anything like this, that's a lien waiver, you know what you're signing. There's specific statutory language that has to be followed when it comes to lien waivers. And so if somebody is not following this particular statute or the language, it's possible that the lien waiver is not enforceable. It's possible. But I wouldn't guarantee it. If it doesn't, if it smells funny, then don't sign it. You can always find one online that will be enforceable and just go ahead and sign one that's right. Tell them you'll provide your own. All right, so there's always a risk, even with this. The process for signing lien waivers. So you've got your progress payments, which go first, obviously, and then at the end, you've got your final payments. So you've got conditional and unconditional for each. Conditional waivers on a progress payment is when you're basically saying, hey, here's my pay app, I will sign my rights. I'm conditionally saying I'm waiving my rights to a lien. And then once my lien, once I do get full payment and it's cleared the bank, I will provide you with an unconditional. And it's the same thing for the one on final payment. So you start a job, I guess we can go to the next slide because I think it spells it out a little bit clearer here. All right, so the way this works is you submit the conditional waiver and release on progress payment at the same time you provide a pay application. So you have your pay application and then you've got your conditional waiver and release on progress payment. You want to make sure, and this is really, really important, that the time frame, that time period on the waiver and payment application is the same. You don't want to sign a waiver for a time period that you are not yet ready to waive your lien rights for, because lien law is so heavily reliant on the time period where you performed your work. If you put in the wrong dates, you could potentially be waiving your rights to a lien for work that maybe you haven't even performed yet. And so you want to be really careful about doing that. And, you know, just being honest with you guys, we've seen GCs provide lien waivers that have it for the entire project. You're signing a lien waiver that's for the time frame of the entire project, and it's shady, but if they can get away with it, they're going to try to get away with it. Or sometimes they will, depending on who you're working for. So the first agreement on the progress payment, this is conditional. You're saying, hey, I'm not waiving my lien rights yet, but I will as soon as the payment clears the bank. So the next time you present a pay application, you're going to have an unconditional, and then you're going to have another conditional, because you're going to have another pay application that needs a conditional release. So you go with your next pay application. If the payment from the first one has cleared the bank, then you will sign an unconditional waiver for that pay period, because you've been paid, so you no longer need to have a lien for that. With your new application, you're going to sign a conditional, and that's the process all over again, saying, hey, once this payment clears the bank, then I'll give you an unconditional. And we know that there are times where somebody will try to force you to sign the unconditional before you've been paid, or they'll say, hey, I need you to sign this unconditional at the same time you pick up the check. You want to make sure that that check has cleared the bank. The funds are deposited. They're not on hold. They can't be canceled. They are clearly in the bank before you give them that unconditional lien waiver. Don't let them bully you into signing the unconditional before you've been paid. All right, so when you get to, we'll go back one really quickly. When you get to the end of the project, you still have your retainage and you got your final payment. And so this is where the final pay application comes in. So you submit that final pay application, and then you got your conditional waiver on the final payment, which says, hey, I'm owed this, and include your retainage. So once you're paid everything, including retainage, and I know sometimes you'll hear, oh, but the whole project is not done yet, so I can't tell you what retainage is. Here's the thing, you don't want to sign anything unconditional until you've been paid everything. You're going to supply the unconditional waiver on final payment, and now you no longer have any lien rights at all for this project. Okay, now we can move on to the next slide. All right, so if you're being asked to sign that unconditional waiver before you're paid, don't do it. They're not even allowed to do that. They shouldn't be allowed to do that. It's illegal. But we know we live in the real world, and it happens all the time. And somebody's going to say, well, I'm not going to pay you unless you sign this unconditional waiver. And that's really, it's not how it works. Why would I ever do that? That only benefits you. So while it may be against the law to have someone sign that, it doesn't mean that they're not going to try to use it against you anyway. And so you definitely want to make sure that you are not signing those waivers until payment has cleared the bank, especially if you're not familiar with the person you're working for. It's your first time on a job with them, or you maybe don't know so much about them. You want to play it safe the very first time. If you have a relationship with somebody and you trust them, I would never recommend not getting things done in writing and not following the process, but I understand some people function like that, and they're like, oh, I trust this guy, it's fine. Even with that though, I still would recommend you get everything signed the way it's supposed to be signed and when it's supposed to be signed. So you want to make sure everything is being correctly followed, and if it's not, your red flag needs to be going up. You ought to be real sensitive as to why things are not going that way, because chances are it's not for your benefit that they're going off to the side and doing things differently. All right, so like I said, you can Google these, I'm pretty sure, and in the Texas Property Code, you'll find the documents, the conditional and unconditional on progress payment, and the conditional and unconditional on final payment. So if you really want to know what those look like, or you're suspicious that something you've been given doesn't quite follow the language that's required, you can always take a look at those in the Texas Property Code and compare them, so that way you know. And if they're not providing them, you can get your own and provide them. And that's all the topics that we covered, and so now I'll take the questions that Miss Jackie or you all have.
Thank you, Courtney. Thank you so much for that presentation. And just before we get started on questions, everyone, you can go ahead and put questions on in the chat and I'll read them aloud, or if you want to unmute yourself and ask a question, you're allowed to do that as well. And Courtney, I'm having a trouble seeing you. Can you make sure that your camera is on?
Sorry. Yes. Sorry.
There we go. All right, so yeah, we'll open up to questions. Anyone have, a current example, past example that they, want Courtney's opinion on? This is a great time to get her advice and rack her brain on all
This is Chris Robles. Question.
Hey, Chris, how you doing?
How you doing, Miss Strickland? How are you?
I'm good. I'm good. It's good to hear from you.
I hear you. It's good to hear from you, and I'm glad that you.
Oh, you're breaking up.
Sorry that there's a pause. I'm driving, and I'm on this call. So one of the things that can help Sorry, Courtney. That's very driving.
I can't.
Can you hear me?
You're going in and out pretty badly. I don't know if Jackie can hear you and maybe she can translate it, or if she's hearing the same thing I'm hearing.
I can't. Yeah, you're going in and out almost every other word.
How about now?
It's better.
No, that was clear.
So one of the things that subcontractors can use is the AIA contract. Even though the general contractor may not be using an AIA contract, they still have the ability to use an AIA contract, which has a schedule of values, which you on your retainage percentage, and drive the general contractor so they can't avoid you on it. And then the comment that I have, payments always have to go through the record.
You got to say that last part again.
Payments must go and be approved by the architect and the designer of record. So they're above the general contract. And that is the hinge point that keeps the general contractor and the architect and engineer down to the contract. A general contractor cannot just pay you just to pay you. It must go through the AIA process.
Yeah, that's correct on an AIA contract. Those terms are pretty specific, and I know with the AIA you can kind of get in there and tweak it to, include whatever terms you want. So yeah, that's definitely a part of it. It's just an added layer of who gets to approve what.
That's right, and the Cromines law firm really taught me a lot about that, and I'm just very thankful for that. And specifically to you, Courtney, you're 100% correct when it comes to the lien waiver. Don't
Thanks.
sign a waiver unless you have been paid.
Absolutely. It's a dangerous road to go on. It really is.
It is. It's very costly, but having the Cromines law firm, it'll help you out, whoever's on the call. And I'm just very thankful for that. So anyway, that's my comment and question.
Thank you so much, Chris. I really appreciate you saying that, and we definitely need to catch up a little bit. I don't think I've since it's been a while. I talked to you last right before I was having some big life changes, so we're definitely gonna have to catch up after this.
Yeah, absolutely. But so thank you very much for hosting the call. And it's all the truth, people. If you're out there on the call, it's the truth.
Thanks so much, Chris. I'll give you a call too. I'm so glad you could join us.
Yes, ma'am. Thank you very much.
Thanks.
Thank you, Chris. All right, do we have any other questions? Any other questions for Courtney in regards to a contract or a current project or job? You can, let's see. Robert asked if he can get a copy of the presentation, and yes, I'm going to send out a copy of the presentation via email to everyone later this afternoon. So yeah, be on the lookout for that. And we also recorded this. Well. Any other questions? All right, well, I don't think we have any other questions, Courtney.
That's actually awesome. I'm happy to hear. I hope that it was clear enough to not need any questions. Although, you know, I'm happy to answer if somebody has a specific question related to a specific project that they're working on. I'm happy to kind of tell you what I think about it. But I mean, I think that's great that everybody's got a pretty good understanding of this.
Yes, thank you. And this presentation and information is so important. Like I said at the beginning, here at the Cromeans Law Firm, we're all about being proactive and preventative, so that you don't end up in a lawsuit, that you don't end up in the courtroom, and that you can be focused on growing and leading a successful business. And so making sure that you're reviewing your contract beforehand, making sure that it's a fair contract, and reading through those clauses. And if you ever need help with reviewing a contract, or you have one where you're not quite sure what they mean or how to negotiate, give us a call. We'll have flat rates for our contract review that are dependent on length, and I'll send that information out in the email as well. So, all right. Well, thank you, everyone. I'll let everyone get back to their busy day, and have a good rest of your week.
Thank you guys so much for taking the time to listen to this with me. I appreciate it.
Great. Thank you.